Thank you, Mr. Chairman, representatives. My name is Josh Tanner. I'm a representative from District 14. And if that was the case, I just would say yes, vote for it, and I can sit back down if you want. That's all we need. But this bill deals with transparency. In the end, that's really the big item within this, is the transparency aspects. And these large corporations, these large banks, banking and merchant processors are not being transparent. This bill deals with debanking. A lot of people, even including myself, a few years back, I didn't realize debanking was even a thing. And then the more and more research I actually did, the more and more I found out wasn't just happening, it was actually shady on how it was actually happening and how these institutions were targeting Americans. For the banks, though, themselves, it makes me even more mad because they got massive bailouts with our tax money. And then they turn around and tell us that they can debank us for any reason. They don't have to tell us why. They can shut our accounts down. They can shut our auto deposits off. They can shut our debit cards off. They can do a lot of things with us without having to tell us why. And then as you start looking at the list of people that have actually been, especially organizations that have been debanked, it becomes very alarming at what they're actually doing and who they're actually going after. So one of the things I want to point out, this deals with banks that are $100 billion in assets for both the banks as well as merchant processors. So this does not affect Idaho chartered banks. This doesn't deal with the banks here within Idaho. This threshold is set high enough that it's beyond that. Within the bill itself, though, some of the things that it actually addresses, it deals with social credit score. Again, social credit score should not be something that banks should be looking at based on their evaluation of us. Banks should be looking at what is actually the risk would be your financial credit score. If they're looking at you as a person for how credible you are, you're going to pay things back. Those are the types of things they should be looking at. They shouldn't be going after you for how you believe, your speech, your expression under the First Amendment. It shouldn't be targeting people with certain industries just because they don't like those industries, they don't align with their own political or values. That is not what these banks are supposed to do. One of the things I'd point out, though, is just under the Troubled Asset Relief Program. This was a fund that was actually done. This was the last bank bailout that actually happened in the last downturn when banks realized they made some big boo-boos and they were all of a sudden all in trouble. They came to the American people and said, we're going to have to get bailed out. Bank of America, $45 billion. JP Morgan Chase, $25 billion. Wells Fargo, $25 billion. U.S. Bank, $6.6 billion. And these are the same institutions that are now debanking organizations and individuals all across this country. And for Idaho, I think this thing needs to stop. This does give the repercussional action, does give them within that the direction of what they're actually supposed to, how the time frame and they have to respond. So if a customer was had an issue, they'd have 90 days to submit to actually why was I debanked? Why did you shut everything down on me? Grandma goes to get gas and she was actually debanked. She should get to know why that was. And for some reason, these banks go, no, we don't have to tell you why that actually is. Within that, it tells them that once they get that notification, they have 14 days to actually respond back of what is going on. Still, even within that time frame, I think that time frame is still too long. I personally don't think we should even give them that amount of time frame, but we are giving the time frame to deal with it. Because if you are debanked and they actually are holding your money and they're not allowing you to function, because most people anymore don't carry around bricks of gold in their pocket or large amounts of cash, they have their debit cards. Or potentially credit cards, or if you're a bank, or if you're a business and you're actually have a merchant processor and they shut you down, 90 days could be a long time that you're not taking potential revenue while you try to get another merchant processor to take you up. And usually that's the case, you're trying to get it done quickly. That's usually not going to work out very favorably in your sense. But what we've allowed in this is we put in here for the Attorney General. So the Attorney General may undertake any and all action authorized by the Idaho Consumer Protection Act to investigate and enforce a violation of this chapter. So it allows people to actually have a means to be able to go back against these large institutions when this type of thing happens. With that, I'll stand for any questions.
Okay. Thank you, Representative Tanner. Any questions for Representative Tanner? Representative Wheeler.
Yeah, question if I may, Mr. Chairman.
Yes.
Representative Tanner, just curious, my understanding is, this is one of the most regulated industries in the country, and I'm curious, we've got on whatever, page 3, I think, for the enforcement, we've basically got a potential civil cause of action if the banks are not responsive to this 90-day notice of why they were debanked. And I'm just curious, what are the chances that we kind of put the banks between a rock and a hard place where there's federal regulation of things that they can't tell the customer after they've debanked them, and now they're subject to a civil private right of action?
Representative Tanner.
Thank you, Mr. Chairman. Representative, I don't really care what somebody was debanked for. They should get to know what was actually going on with their account. There's representatives that are sitting in our that are other representatives with us. There are senators that have had family members just recently have this happen to them, and then come to find out what it sounds like is there was maybe potential fraud on their account. That is something that they can tell the person. These large institutions, they operate way outside of us. They don't spend money lobbying, usually. Idaho, I actually think some of them actually do, most of them actually, but they lobby heavily in DC, and hence the reason that they get billions of dollars when they make boo-boos and they get themselves in trouble. I'm not that fond of the policies and at all that are in place. I'm here about protecting the people of Idaho and making sure that the people of Idaho get a chance to actually understand why they were debanked, what was actually going on, and if they were having these type of things violations that we're listing out in here done to them. And at that point in time, they actually do have civil action that they can take back on that, because this is now stating that they cannot do it for those reasons that they've done to other people across this country.
Okay. Did you have a follow-up?
Quick follow-up if I could, Mr. Chairman, yeah. Thank you, Representative Tanner. And frankly, I'm supportive of this effort to, provide consumer protection for Idaho citizens for sure. I guess if you could speak to, are there federal regulations that would, run afoul of these requirements that we're putting on the banks?
Do you know of any? Representative Tanner.
Yeah, good Chairman, Representative. I don't know of any off the top of my head or any that I've actually read, and I've gone through quite a few of them. Again, from what I understand, these banks don't have to, based on some of the aspects, disclose certain things. This is just saying, for Idaho, you will.
Okay. I don't see any other questions from committee. So at this time, I'm going to turn it over to public testimony. We have several people signed up to testify. We have one virtual?
2 virtual.
Okay.
Or sorry, just 1 virtual.
Okay.
1 in person.
So the first one would be Tony Ulrich from Hammett. Tony?
Mr. Chairman, members of the committee, I'd like to thank you for this opportunity to speak on, Senate Bill 1027.
Can you give us your for the record information?
I'm sorry, say again?
Give us your for the record information, your name and who you represent.
My name's Tony Ulrich. I'm the state chairman for the Constitution Party of Idaho.
Okay.
And last March, right before the presidential primary, U.S. Bank sent us out a letter. I received it in the evening. I laid it next to my chair to have some coffee in the morning and read it. We just received our bank statement, so I assumed it was advertising or, the things that banks usually send you out. When I woke up the next morning, I opened the envelope and I found a check for our account balance and a notice on it that just said account closure. No explanation, nothing whatsoever. I was really shocked because, like I said, we just received our bank statement. We just recently, within the last month, changed leadership within the party, got new account signers, and we'd all just received our bank cards. I mean, literally within the week previous. There was no explanation. I immediately called the helpline to find out what was going on, and I spent 2 hours that morning on the phone with their customer service representative and could get no answer. She suggested that I contact my local branch and see if they could help me better. So when my branch opened, I took some time off of work, went down to my local branch, and I spent almost 2 hours again with our branch manager, who escalated the situation several times, and we just couldn't get an answer. I finally, about 2 that afternoon, received a call from U.S. Bank, and they said they simply just decided to not do business with us anymore. You know, normally under most situations, I would say, well, that's, a small business is right. I'm not one to, support much government regulation whatsoever, but banks have become basically a quasi-government entity. I mean, the U.S. government and much of the state government has required us to simply have bank accounts. We need them for everything these days. And to not have a reason why they closed an account that was over 15 years old is just unacceptable. I mean, a simple reason is all we're asking. And this bill simply asks for transparency to notify us why. So we have a reason, so we know why. I mean, to my knowledge, I've only been the state chairman for 4 years now. We have never had an overdrawn. We've had the account since at least 2008 that I could see. We've never been overdrawn. We're no financial risk to the institution. The only thing that we can see would be our political affiliation that would drive the corporation to shut us down. They don't like our politics, and that's wrong. That should happen to no Idahoan, and it should happen to no U.S. citizen. So, and with that, I will stand for any questions if anyone has any.
All right, thank you. I don't see any questions, so thank you very much, Tony. Next up, we have someone online, Matt Sharp, virtual. Showing up.
Says he's rejoining.
Here we go. Okay, Matt, can you hear us?
Yes. Good
Yeah, we
afternoon,
can see you. Yeah.
Mr. Chair.
If you can give us your for the record information and give us your testimony.
Thank you. My name is Matt Sharp, and I serve as senior counsel with Alliance Defending Freedom. In the 1930s, in a despicable practice known as redlining, financial institutions created maps with certain neighborhoods marked in red. Lenders viewed residents of these neighborhoods as hazardous or too risky and would not issue them home loans. But as we know, such redlining was not based on financial risk. It was based on racial discrimination against predominantly Black neighborhoods. Today, we are witnessing a modern-day redlining under the guise of so-called reputational risk. These banks and payment processors are discriminating against businesses and consumers because of their religious beliefs and political views, or because they're in the firearm or energy industry. For example, last year, Bank of America closed the long-standing account of our firm's client, Indigenous Advanced Ministries, a Christian nonprofit that helps impoverished widows and children in Uganda. Bank of America claimed it no longer wanted to serve their business type and that Indigenous Advance exceeded the bank's risk tolerance. This cancellation happened right before a mission trip to Africa, causing irreparable damage to Indigenous Advance. In fact, it couldn't pay its poverty-stricken Ugandan workers for several weeks. Last year, we learned that several Indiana-based firearm companies were debanked by major banks or credit card processors with no notice or explanation. As we heard, Senate Bill 1027 would remedy this, providing transparency and remedies for consumers, because Idaho business and consumers need protection against this growing risk of debanking. They should never worry that their bank account will be shut down or that their card will be declined. Ultimately, this bill sends a signal to local businesses and consumers that the legislature is standing with them, those who built Idaho into the thriving state it is today, rather than with the massive financial institutions pushing a woke agenda. And finally, to respond to Representative Wheeler's questions, there is no conflict with federal law regarding disclosure. And if there was, this bill addresses it. So on page 3, lines 11 through 12, in the transparency and written explanation, it specifically says, unless otherwise prohibited by law, the financial institution shall transmit the explanation. So this addresses that concern so that there would be no conflict with federal law. Thank you.
Okay. Thank you, Mr. Sharp. Any questions? Representative Birch?
Thank you, Mr. Chairman. Thank you, Mr. Sharp, for being here. When were you told that your account was canceled specifically because you're a Christian organization? Or what was the extent to the explanation you got?
Mr. Sharp? Did you hear the question?
Mr. Chair and Representative. So again, this was on behalf of our client, Indigenous Advanced Ministries. So what happened was their account was closed, no explanation, no reason given. When they tried to get one from Bank of America, they were initially stonewalled. They couldn't get a reason, they couldn't get an explanation, continued to be dodged. It wasn't until a reporter in the United Kingdom heard about their story and began reaching out to Bank of America that Bank of America began to say, well, it's because we don't serve your business type or because of the risk, again, this reputational risk. So that's part of the problem, is they had no idea why they were canceled, could not get a written explanation or any answer, and that had huge impacts on their ability to continue their missions work.
Representative Birch? Okay. I see no other questions. Thank you, Mr. Sharp.
Thank you.
We have, just for everyone's information, we do have some written testimony that was submitted by the ACLU that was just handed out to you. We thought it was in your packets, but we just handed that out. We have a sign up of Stacy Satterley that would like to testify. And Stacy, you and I met yesterday, and I know that you've got some deep questions to be asked or comments. So I'm going to allow you a little more than 2 minutes. So we have plenty of time technically. So thank you.
I appreciate that, Chairman Clow and members of the committee, and I appreciate the opportunity to stand today and talk about Senate Bill 1027. We understand that this bill is a priority of members of Senate and House leadership. So rather than stand here today and oppose the bill, we're going to ask that you consider sending this bill to the amending order. We also want to thank the pro tem on the Senate side. He was willing and accepted one of our amendments, and in our opinion, it made it a better bill. We think there are still some changes yet to be made. By way of background, financial institutions are subject to a large number of state, federal, and local laws. Large banks we're talking about in this bill are regulated by multiple federal agencies. There are situations that arise that cause a bank to exit an account. Some of those reasons are poor credit performance, fraud concerns, potential criminal or terrorist activity. Each year, banks close a very small percentage of accounts to ensure they are continuing to comply with all of the financial crime regulations and requirements. It is simply not the case that a bank would exit or debank a customer based on their connection to a specific industry or based on their political affiliation. Banks do not use a social credit score to determine provisions of financial services. They use risk-based criteria, sound criteria to make those decisions. There is no metric that exists that is a social credit score. Again, we might hear about it on social media, other places, but it is not a metric that banks use. There are federal laws that pertain to all of this. The Bank Secrecy Act, the Anti-Money Laundering Act, and the Patriot Act, and others that require banks to report fraud concerns to their regulators. And when fraud concerns are reported, federal regulators require that those accounts be closed and that banks cannot disclose at that time why the account was closed, which makes some sense. You wouldn't want to tip somebody off as to fraudulent activity if that's what was happening, if that was what was happening on the other end of the account. This creates a vacuum, and that's the vacuum that we're seeing here. An account is closed for what is a valid reason, but the account holder can't be given a reason per these federal laws. And then they can claim that it is for some reason other than what the actual reason is. If this law is enacted as it's written today, the result will be, or could be, lawsuits pouring in to banks for every account closed or every loan that's denied, whether or not, and again, what we're suggesting is for valid reasons. Another kind of aspect of the bill as it's currently written is that it would allow anyone, anywhere to sue, not just Idahoans. A number of these other laws that have dealt with these kinds of issues have included geographical boundaries to apply in the state of Idaho. So for example, as the law is currently written, a California resident doing business in California with a bank that also has a branch in Idaho could sue under this Idaho law. It is true that certain industries are inherently riskier than others, and not every bank has the necessary expertise or experience in every industry, in every kind of transaction, or in every funding agreement. Banks need to be able to identify areas of focus that make good business sense, that do not put them and their customers or their customers' assets at risk. The effect of this legislation could be to indirectly force banks to take risks that are not appropriate based on the threat of lawsuits. There are two other states that have enacted this legislation or similar legislation, and that's Tennessee and Florida. One was last year, one was the year prior. The amendments we're asking you to consider would bring Idaho's bill more into alignment with what is on the books in Tennessee and Florida, where banks are already complying with those laws, which would make it more reasonable for them to comply with the law in Idaho. So first, we would ask that you remove the private right of action in the bill, which is on page 3, lines 43 and 44. We agree that the Attorney General should investigate and enforce violations of this act without opening the door for all kinds of, a lawsuit industry here in Idaho based on this. If members of the committee are not interested in removing the private right of action, we would at least ask that you limit the scope of the bill to persons in Idaho to keep opportunistic out-of-staters from taking advantage of this law. Also, we would ask that you consider a simpler, consistent complaint process so that banks can manage complaints and respond appropriately. The amendments we provided spell out a process that is closer to what is in place in Florida and Tennessee, and these changes would make the process clearer for everyone. We also did ask for a change in the timeline. 14 days was pretty quick to receive a complaint, investigate the complaint, and respond, so we asked for 30 days rather than 14. Thank you again for the opportunity, and I'd stand for any questions. And I also will disclaim that I'm pretty new at my job, so if it's highly technical, I may phone a friend in the audience, if that's all right.
All right, Ms. Satterley, you indicated some amendments. Did you write some new amendments that I haven't seen yet? Because I saw a list of things the other day.
And Mr. Chairman, per your sage advice, we whittled the list down to what we thought was the most important.
Okay.
And it was only maybe 20 minutes before committee, but I did send them to the secretary to be distributed. Too late.
Okay. So we don't have them specifically.
I have some copies.
Okay, if you've got a copy for the page.
I do. I apologize.
Mr. Chairman,
Yes.
that's great, she's got amendments and everything, but you're talking about a member's bill here. Has she shared them with the member? Is the member okay with the amendments? Is the
Has it-
sponsor and the Senate okay?
I haven't seen them, and I don't think she's shown them to the member, but I told her if she had anything, that she'd need to be very specific, and that's what she's doing. I'm not trying to jump ahead, and I'm just trying to get out in front of us exactly what their concerns were. So.
And Mr. Chairman and Representative Crane, this is an excellent question. We communicated with the pro tem when this bill was on the Senate side. Admittedly, we had a series of meetings yesterday. We were unable to meet with the bill sponsor. Everybody's really busy, and also admittedly, the hearing came up rather quickly, so I apologize. We made an attempt to reach back out to the pro tem and meet with the bill sponsor, and we were unable to do so.
Okay. Preston, if you could grab the amendments that she has. Okay. Do we have any questions for that while she's bringing that forward? Yeah. Representative Wheeler?
Yeah, Mr. Chairman, just a short question if I might.
Yes.
Ms. Satterley, I wonder if you would just explain to us, you had mentioned that Tennessee and Florida, I think, are the other states that have this bill. Do they have the provision in their version that only designates citizens of their state? Because that was one of the requests you had. I'm sorry, I can't remember. In the definition of person, you were suggesting it would be better if that, on line 5 there, if it said, other business or legal entity in Idaho. Does Tennessee have an in Tennessee and Florida have an in Florida?
Mr. Chairman and Mr. Wheeler, I don't actually know that. I don't know if that's true. You know?
She's looking for a lifeline.
I was gonna say-
Apparently no.
And Mr. Chairman, I think our thought process there was ESG type bills that the Idaho legislature has considered in the past have generally included those geographical boundaries. So I'm happy to find out whether Tennessee and Florida includes that and follow up.
Representative Crane?
Thank you. Yeah, I was not done there, Mr. Chairman. I got a couple of questions. So $100 billion threshold, is that any Idaho banks that would affect?
Ms. Satterley?
Chairman Clow, Representative Crane, Idaho chartered banks fall below that threshold. There are banks that do business in the state of Idaho and serve a large number of Idahoans that are impacted by that threshold.
Okay. Representative Crane?
Thank you, Mr. Chairman. And Ms. Satterley, I think that you had mentioned that you don't have the ability to let individuals know why their account has been closed. What is the prohibition of why you can't let people know why their accounts have been closed?
Ms. Satterley?
Chairman Clow, Representative Crane, the restrictions or the provisions within the federal acts, the Anti-Money Laundering Act, the Bank Secrecy Act, the Patriot Act, that don't allow, once fraud has been detected, and then federal regulators require banks to close accounts, that don't let the banks disclose why the account was closed.
Follow up?
Yeah,
Thank you,
Representative
Mr.
Crane.
Chairman and Ms. Satterley. So I'm going to use Doug Taylor as a foil here. So Doug is let's say he's a drug lord and a money launderer and doing all kinds of nefarious stuff with his banking activity. The feds are onto him. They're watching him. You decide to close his accounts down because you've proven that. You're saying that federal act says you can't tell Mr. Taylor, hey, we've shut your accounts down because there's a pattern of suspicious financial activity?
Ms. Satterley?
Mr. Chairman and Representative, correct. And my sense there is that the federal agencies that are doing the investigating don't want Doug to run off and reconfigure his businesses, and try to further hide what he's doing or tip him off to the fact that they're onto him, and he might end up, with people knocking on his door before much longer.
I'm sorry.
It's okay.
Yeah,
Thank you,
Representative
Mr.
Crane.
Chairman. Ms. Satterley, Doug's a good guy. He'll stay in Idaho if that happens. But my understanding and the information that I've received is that they can in that act. That specifically allows them to do that. And so that's what I'm trying to figure out. Your testimony is contrary to the information I'm getting. So I'm just trying to get to the bottom of that. So we can talk offline if we need to.
Mr. Chairman and Representative, I'm happy to follow up with more, specific language on that.
Okay. Thank you. Representative Wheeler?
Yeah, Mr. Chairman, a question if I may, and it's Representative Crane's fault that I have this question, so. I'm just curious, the way that we have this legislation currently written, Ms. Satterley, could you not even notify, an Idahoan who's being debanked in this case that their account is being closed for something that falls under that umbrella? Can you not even say to them, like, there are federal acts that, that your account ran afoul of? We can't go into details because of those federal acts, but you can't even tell them that?
Ms. Satterley?
Chairman Clow and Representative, I believe there is a letter. It is very vague. I don't know if it cites the federal laws that prohibit the disclosure. My sense is it probably is not that specific or that detailed, again, so as not to tip folks off.
Okay. I don't see any other questions at this time, but we all have the amendments that you're suggesting, and I'll just summarize them, that on page 2, line 5, you want to add the words "in Idaho," but you also want to cross out "a person harmed by a violation of this chapter may initiate a civil action." Okay, you mentioned that one. And then explanation required upon request if a customer reasonably believes that a violation is subsection 2A below. So you're just changing around what they can request. Is that correct? And that's in item 2 of your amendments.
Chairman Clow, that's correct. It would allow banks to have a similar process in Idaho as to what they've already got in place in Tennessee and Florida, so they don't have to have a significantly different process here that they've put in place in those other states on this specific issue. And to just follow up on your first point, I think there's some merit to adding in Idaho regardless, and it was a little bit of a, we understand it may be one or the other if you're, depending on the committee's positioning on the private right of action.
Okay. All right. I think I told you yesterday that I didn't have a lot of high hopes for amendments, but if you wanted to provide them specifically, so.
That's right.
Is there anyone else in the room that was planning to testify today?
Thank you.
I thought Representative Harris was going to the podium. Okay. All right. Then there's nobody left online. So that closes the public testimony portion of the meeting. And I'd call back up Representative Tanner. And you've had a chance to look at the amendments, and you can weigh in on your thoughts about that.
Thank you, Mr. Chairman. Well, first off, extremely frustrated that you would allow a lobbyist to come up here and extend her time to have a hostile motion on my bill that was not presented to me. She came and said that she didn't get a chance to come present this to me, and you allowed this to continue to go on.
Mr. Chairman, could we go at ease for just a second and step out back?
Yeah, sure. Let's go at ease. Order. Representative Tanner, do you have any closing comments?
Yes, thank you, Mr. Chairman. So amendments were presented originally to the pro temp as this bill was actually getting done on through the Senate side. They did take in one of the options that they looked at, but I think some of the industry is still not that happy with this. Again, our job is not to make these large institutions that are $100 billion in assets the happiest people in the world. We're supposed to make their constituents the people that are the happiest people in the world. I do want to point out just really quickly on the debanking aspect on some of them that were actually the ones that we're looking at and addressing. We have religious institutions, one of them being Sam Barrowman, or Barrombach. Again, was a senator, was a U.S. ambassador for a nonprofit, religious nonprofit, and in the end, they came back and they said, well, wouldn't tell them why they debanked him. Then they came back and said, we want to know all your donors. I did the same exact thing to public television. I said, well, we've got a private public entity. I want your donors. And they said, absolutely not. But that's what they've asked for. You've got political ones, Mom for Liberty, Defense for Liberty, Idaho Constitutional Party. All of those ones were debanked in a sense because of reasons that really this bill addresses. The other ones were firearms. Were another one. Banks don't seem to like firearms very much. I'm not sure why, but the National Rifle Association, Silencer Central. I own 5 different silencers from Silencer Central, so when I saw them on the list, I was even more upset. But within that, this bill does address the issues that protect Idahoans, and that is where we should leave this. I'm not looking for amendments to this bill. I'm looking for this bill to be sent to the floor with a due pass. This bill did pass the Senate 32-2 with bipartisan support. So thank you, Mr. Chairman.
Thank you. Any further questions for Representative Tanner? Did you have a question?
Motion.
Okay. Any other questions? Okay. Motion?
Thank you, Mr. Chairman. For a motion,
Okay,
I move to send Senate Bill 1027 to the floor with a due pass recommendation.
okay. We have a motion properly before the committee to send Senate Bill 1027 as amended, to the floor with a due pass. Any discussion on the motion? Representative Birch.
Thank you, Mr. Speaker. I will not be supporting the motion. If I could speak to that, please.
Yes?
Thank you. Excuse me. So I absolutely agree that there should not be any discrimination, religious or political or otherwise, or for that matter, for sexual orientation or any other reason that has nothing to do with engaging in the business of banking with another entity. But this bill assumes that that the need for this legislation is because of religious or political bias by big banks, and that was reflected in both the testimony that we heard and the statement of purpose, which specifically calls out social credit scores, which is really a political football issue. Businesses, there could be all sorts of reasons why someone doesn't do business with a particular organization that has nothing to do with their political or religious beliefs. And I'm sure that there are organizations that might be more aligned with, might be considered progressive causes that also don't get to, that banks may not do business with, that may have nothing to do with their political beliefs as well. But the thing I'm most concerned about this bill is the enforcement part of it, because this allows any future attorney general, quite frankly, to go on a political witch hunt based on assumptions without actually, I think they might be doing this for political or religious reasons. And there's an inherent risk of intimidation to private businesses when you write laws like this and you give Attorney General the power to go after whoever he wants, whenever he wants, because he suspects or she suspects something. I think the point about right to private action was also a legitimate concern as well, especially for people from out of state. There are a lot of people messing around from out of state in other states, whether it's people from outside of Idaho or who are really trying to use the legal system to mess with things for whatever their own particular causes. And at the end of the day, while the intentions, I think, are fine in terms of making sure that we're not seeing this religious or political bias in banking, it's going to hurt. It can hurt Idaho for banks deciding, we're just not going to do business in Idaho because there's too much risk, because too much power has been given to some future attorney general who may be on on some more of a political motive, so we'll just skip Idaho because it's not worth it. At some point, it's always easy to point a few, anecdotal situations, which is never the complete story, and you really don't know the details behind it. And so I think that there's a better way maybe to approach this. I don't think this is the right way to do it, because I think there's too much inherent risk to Idaho businesses and to really inviting a lot of lawsuits that will create more problems than it clearly will solve.
Okay, thank you. Any other discussion on the motion? Representative, who's that? Razor, okay.
Thank you, Mr. Chairman. I don't normally like to use anecdote to support something that I'm intending to do. I'm going to be voting on this on principle, but everybody needs to remember that every statistic was at one time a group of anecdotes. And I actually had this happen to me. Now, they did provide the reason, but my money was held. I wasn't as lucky as Mr. Ulrich. My money was held for months, and I had to resort to some unique methods to get it back. I will leave those to your imagination. But the unfortunate thing is that this is real people that are damaged by this. It's not some gigantic institution. It's somebody who several $1,000s, which doesn't sound like a lot of money to most of the people in this room, meant quite a bit to. So I don't want to use that anecdote, though. This is a good method of protecting Idahoans, and I will be voting for it.
Thank you. I see no other lights, so I assume everyone's ready to vote. I'll call a roll call vote on this. So the motion is to send Senate Bill 1027 as amended to the floor with a due pass, made by Representative Redmond. So roll call.
Chairman Clow,
Yes?
Vice Chairman Redmond,
Yes.
Representative Crane,
Yes.
Representative Palmer, Representative Barbieri,
Yes.
Representative Cornelis,
Yes.
Representative Crane 12,
Yes.
Representative Ehlers,
Yes.
Representative Monks,
Yes.
Representative Cannon,
Yes.
Representative Harris,
Yes.
Representative Marmon,
Yes.
Representative Razor,
Yes.
Representative Wheeler,
Yes.
Representative Birch, Representative Shubin.
Motion is passed 15-2. So, there will be, our next meeting will be on Monday, and we have another Senate bill coming forward. And Representative Tanner, you'll carry this on the floor? Yes, sir. Okay. And we go to the floor at 3 o'clock, or 3:30? Was it 3 o'clock? Yeah, 3 o'clock this afternoon. With nothing more to come before us, the meeting is adjourned.